Domestic violence. Published by South Carolina Bar. The Protection from Domestic Abuse Act is a law in South Carolina to protect wives and husbands, former spouses, children and other close relatives from physical harm, threat of harm or criminal sexual conduct by providing help through family court to get a protective order. Physical abuse occurs in various forms, being kicked, punched, slapped, shoved, sexually molested or harmed bodily in any way. The person who has been abused or threatened with abuse can ask for help from family court under the civil laws. If the abused or threatened person is under age 18, another family member can ask the family court for help. You do not need a lawyer to get a protective order. Go to the clerk of court in the county where the abuser lives, where you last lived together, or where you live if you cannot find the abuser. The clerk of court can give you forms to file your own papers and will schedule a hearing on the matter. If you cannot afford to pay the filing fees, the clerk will show you how to file without a fee. During times when the court is closed, you may go to a magistrate to get a protective order. A protective order issued by the family court can tell the abuser to stop abusing you and to leave the home. Family court orders can also order temporary child custody, child support and visitation rights, and possession of your personal items such as clothes and medicine. Protective orders issued by magistrates are more limited and can only tell the abuser to stop abusing you. You do not have to file for divorce to get a 6-month protective order. The parts of the order about support, custody, visitation and personal property last only 60 days if you do not file for divorce or legal separation. If you have a lawyer and have already filed for divorce or separation, your lawyer can ask the court for an emergency protective order if you need it. When you go to court for the hearing, try to take with you witnesses, pictures of your injuries, police reports, medical reports, your financial information and any other evidence you have to prove that you were abused. A copy of any protective order issued will be mailed to you, the abuser, and the local law enforcement agency where you live. The sheriff's department can help see that this protective order is enforced. If the abuser violates your protective order, immediately contact the police, the clerk of court or your lawyer. It is a crime to violate this order. The sentence can be up to 30 days in jail or a fine of $200. It also could be contempt of court to violate a protective order. The punishment is up to 1 year in jail and or a fine up to $1,500 and or 300 hours community service. In addition to the relief discussed above under the Protection from Domestic Abuse Act, separate criminal charges for criminal domestic violence may be filed against your abuser. This relief is available not only to family members but also persons who live together or who live together but never been married. To file criminal charges, contact your local magistrate. If convicted, the abuser can be fined up to $200 or imprisoned for up to 30 days. Repeat offenders face greater penalties. This information was prepared to give you some general information on the law. It is not intended as legal advice about any particular problem. If you have questions about the law, you should consult a lawyer. If you do not know a lawyer, you can call the South Carolina Bar Lawyer Referral Service weekdays between 9 a.m. and 5 p.m. The number is 803-799-7100. FAQs on Criminal Domestic Violence in South Carolina. Published by Schiller and Hamilton Law Firm. With the recent publicity connected to the National Football League, domestic violence has become a topic of much discussion. Many of these conversations deal with the cultural aspects of this type of violence, but there are also important legal issues surrounding criminal domestic violence statutes. For instance, what separates domestic violence from other assault and battery? Does a person have to have a physical injury to be a victim of criminal domestic violence? Can I be charged with criminal domestic violence against a person I do not live with? South Carolina has attempted to answer these questions in detail. Section 162520 of the South Carolina Code of Laws, which defines criminal domestic violence, states that it is unlawful to cause physical harm or injury to a person's own household member, or offer or attempt to cause physical harm or injury to a person's own household member with apparent present ability under circumstances reasonably creating fear of imminent peril. Section 162565, which defines aggravated criminal domestic violence, states that a person may be sentenced to harsher penalties if the assault and battery involves the use of a deadly weapon or results in serious bodily injury, or if there is an assault, with or without the accompanying battery, which would reasonably cause a person to fear imminent serious bodily injury or death. Finally, Section 162510 defines a household member as a spouse, former spouse, a person who you have a child with, or someone who you are cohabitating with or have formerly cohabited with. We will do a more detailed blog about more complicated issues surrounding criminal domestic violence statutes, but our clients are often surprised or confused by the following. Question number 1. I do not live with the person anymore, yet I was charged with criminal domestic violence. Can they do this? Answer: yes. South Carolina's statute clearly gives the state the right to charge you with criminal domestic violence even if you no longer live with a person. This is true as long as you once lived with the person is your spouse or a former spouse, or you share a child in common with the person. Question number 2. My partner and I got in a heated argument, but I never touched them. Can I still be charged with criminal domestic violence? Answer: yes. South Carolina defines criminal domestic violence in such a way that it includes assault as well as battery. Assault is defined as conduct which places another in reasonable fear of bodily harm. The state can use threatening conduct that does not end up in physical contact to support a criminal domestic violence charge as long as you had the present ability under the circumstances to act on those threats, thus creating fear of imminent peril. Question number 3. I did not start the altercation and merely defended myself. Am I guilty of criminal domestic violence? Answer: no. Criminal domestic violence laws do not strip a person of their right to defend themselves in a fight. A person has a recognizable claim to self-defense if it can be shown the other person was the primary aggressor. It is important to note that there is a substantial difference between being charged with criminal domestic violence and being convicted of criminal domestic violence. While the state may make an arrest, they also bear the burden of proving beyond a reasonable doubt that a crime was in fact committed. Hiring an experienced, capable attorney is important so whether there is adequate evidence of reasonable fear, imminent peril, or a person's status as a household member can be properly investigated and challenged.